Hey, everybody. Just wanted to thank you for jumping on this evening. We have a very exciting guest with us here tonight. If you haven't caught any of our webinars in the past, feel free to jump over to our YouTube channel. Just search the Swice Good Group. Just a array of topics that we've covered. But tonight, I'm really excited to welcome to our little group here, Luke Martin, who is an attorney in Statesville and Taylorsville now, North Carolina. They have offices there. I'll let him introduce himself, but I'm going to let everyone have a chance to get on here. Kyle, I don't know if he'll turn his video on tonight, but he's moderating this. If you have any questions while we're going through the webinar, feel free to type them in the chat. And Kyle, if you want to bring those up to me in the private message side or answer them yourselves, and we'll try to answer any questions at the end too that come up in chat. But with that, again, want to thank you for joining. My name is Zach Johnson. I'm an auctioneer and real estate broker with the Swice Good Group. And I am joined today again by attorney Luke Martin. And Luke, for those of the people listening both now and in the future, this will be broadcast to YouTube for forever for people to watch. Why don't you tell folks about yourself, who you are, what you do, and why you're qualified to speak on today's topic, which is the 5 keys to successful estate planning.
Hey, Zach, thanks, man. Yeah, we are a general practice law firm. So I'm an attorney with Benbow, Davidson, and Martin. We have 3 partners and an associate that works with us. We do have offices in Statesville and Taylorsville. We do pretty much any kind of law you can think of. My focus in my practice has been on real estate and estate planning, estate administration, as well as business planning. And those things, especially real estate, has a lot of interplay with estate planning and estate administration because we're dealing with property and assets. So we're exchanging those things, and we have to really have a good grasp on how those things are exchanged. As far as my background, I grew up here locally in Hidnight, still live there today, and started out my working career as a helper in a heating and air company, and went to college when I was 25 years old and went through law school and came here to work, and I've been here ever since. So I really enjoy getting to help people. It doesn't matter whether you're doing heating and air work or whether you're doing legal work or you're an auctioneer, real estate broker, the thing you're doing is helping people. And that's what we like to do here. So looking forward to chatting with you tonight.
Yeah, absolutely. And we want to thank everyone that has joined us tonight on the webinar. Thanks for taking time in your evening to sit down and learn a little bit from Luke. And don't let him fool you. He's very humble, but when it comes to attorneys, especially that are knowledgeable in real estate, Luke is someone that has helped our firm and has helped me personally with any questions. It seems like if he doesn't know the answer, which is very rare, but if he doesn't, he can find out and get back to you real quick. But Luke, when I saw the topic of tonight's webinar, estate planning, my mind immediately jumps to estates. It's someone who's elderly that wants to kind of tie up their loose ends before their time on earth is done. And I think a lot of folks out there probably have that same mindset that estate planning, that's something to deal with when you're older, or we'll cross that bridge when we get there. But you and I had a talk a while back, and you say that's not really the case. It's not just for quote unquote old people or those that feel old.
No, that's true. And that's probably one of the things that I try to tell my clients is, we think that, elderly people, folks who are presumably closer to the end of their life, are the ones who need estate planning, when in fact, it's probably more important for younger people to have their estate plan in place, folks our age and younger. And the reason I say that is younger folks have minor children. And honestly, the probably one of the biggest problems that we see in real estate practice is, or in estate administration practice, is minor children. And how do we deal with assets that have been given to minor children? And courts are very protective of those assets because obviously it's so easy to take advantage of minors. So especially if you have minor children, if you're a business owner, if you, whatever situation you're in as a young person, you really need to be thinking about, okay, how is my estate plan going to affect my family if something were to happen to me? So for younger folks, it's much, much more important to have that estate plan in place than it is for the elderly.
Gotcha. And when you say estate plan, the first thing that pops into my mind in a note that I wrote down a while back is living asset management. Can you kind of go into, I've heard that term a lot, especially in real estate, and especially in the auctions. But my understanding was that just means asset management when you're living. But dive into that, kind of explain that topic to us, the ins and outs of that.
So yeah, the way this normally starts out is someone says, they call our office and they say, hey, I need a will. We say, okay, and we get them in for the consult and we talk about a will, but a lot of times people don't realize that estate planning, not only does it deal with what happens to my stuff after I'm gone, but it also deals with how are my assets taken care of while I'm here. And so we have, whenever we do an estate plan, we always talk about 5 different documents. The one obvious is the will, and we'll talk about that later, but there's some less obvious documents like a healthcare power of attorney. Who makes your healthcare decisions for you if you're unable to? So that's what a healthcare power of attorney would do. A power of attorney, who makes business decisions on your behalf. So if you're unable to manage your assets while you're alive, who would you like to do that for you? So that's part of your estate plan. We also talk about living wills, which is where you would say, okay, here's what I want to happen if I ever become incapacitated, or if I'm ever declared brain dead or incurable or something like that. Do you want to be put on those machines and things? So those are all part of the estate plan. We also talk about trust. Do you need a trust? And those are things that we always go into. And those are all documents, other than the will, those are all documents that are effective while the person is living, and they're part of the estate management or asset management process, so that we do those things as part of the estate plan. So it's not just a will.
Gotcha. Now, when you use the term assets, obviously I understand it as real property or personal property. All assets kind of fall under that umbrella when you say assets. What if you had to give someone just a few bullet points, how the best way to protect their assets, whether they be real estate or personal property, right now, what would that be? What would that look like if you wanted to create a hedge of protection around your assets?
So yeah, we have a lot of folks that come in, especially from the North Iredell, Alexander County areas, who are farmers, landowners. And a lot of times they come in and say, look, I just want to give all the land to my son or my daughter or my children. And oftentimes those are situations where they've had a working farm, and now the children have stepped in and now they're working the farm. And we have to get that real property asset from mom or dad who are nearing the end of life, or they're wanting to retire, slow down. Now we have to transition that asset to the next generation. And interestingly, this is not much different than business planning, where you would have some type of business that you want to have. You need a transition plan for that business. So it doesn't really matter whether we're talking about real estate or some type of intellectual property or something else. We need a transition plan. So how do you want to move out? One thing that we have to think about in any kind of, especially real property, but really any property, is there ever going to be a need for Medicaid? And Medicaid, elderly people are all familiar with Medicare. Everybody will qualify for Medicare when they reach a certain age. But Medicaid steps in if someone ever needs long-term care. in a nursing home. It doesn't matter whether they're an older person or a younger person, they would need Medicaid to cover that. And you have to qualify for Medicaid. And there's certain things that you have to do in order to qualify for Medicaid. One of those things is you can't have given away any property within the last 5 years. And so we have different things that we can do. So when mom or dad come in and they say, hey, we're ready to give our real estate to our children, we typically have a conversation with them about this, because you want to be careful giving away assets if it's possible that you would need Medicaid within the next 5 years. So when we think about protecting assets, folks will come to us and say, hey, mom or dad, they're having to go to the nursing home for whatever reason. And we don't want the nursing home to come along and take their property from them. Mm-hmm. Usually it's not the nursing home that comes and takes the property. Typically what happens is mom or dad will qualify for Medicaid. And then after mom and dad pass, then Medicaid puts a lien on their estate, or goes what we call it estate recovery. So they go into the estate and put a claim on that estate. And that claim has to be satisfied in order to complete the estate process. We have things that we can do that would, one, transition the property to the children, as well as avoid that estate recovery process and continue to keep mom and dad's Medicaid eligibility in place. And so that's something that if that's someone who's listening, they need to contact me or our office or some attorney, and they can advise them on how to move forward with protecting those assets. So other asset protection things that we think about are tax planning. So right now, the estate tax threshold is something like 13 million or 14 million. That was part of the Trump era tax overhaul bill. It was 5 million and they doubled it. It's like 13 million and something now. So if your estate has a value of less than that, you probably don't have to worry about estate tax planning right now. But that could happen in the future. So that's something we always keep our eye on and want to keep our hands on the pulse of that, so that we can avoid any estate taxes and protect those assets from those taxes if needed.
Sure. One thing that I thought of when you were talking about the nursing home situation, can you explain, and this, maybe everyone else understands this, but I ran into a situation with a client lately where there was different titles for different people in the estate, and you may answer this in the future, but it was there's an executor, there was a trustee. What do those terms mean? Like guardian, like what is the difference? You hear that thrown around, I'm the executor of the estate, or in layman's terms, what are those different titles and how do they come about? Is that something you decide beforehand, or is that court appointed, or is, what is that?
Sure. So one of the things that we do when we do an estate plan is we nominate guardians, we appoint executors, and we also appoint trustees. Now those three officers don't necessarily come into every estate plan. So let me kind of break down where they all come from. Most everybody is familiar with an executor. So an executor is the person, whenever whenever an attorney writes your will and you tell them, hey, here's what I want to happen with all of my assets, with all my stuff, I want it, to go here or there. At the end of that, you'll name an executor. The executor's job is to probate the will and to manage the probate process. So the executor makes sure first that claims of creditors get paid. So basically anybody that the deceased person owed money to, they'll file a claim in the estate. The executor has to make sure those folks get paid. Secondly, the executor looks at the will, or if there's no will, if there's no will, there wouldn't be an executor, and we'll get to that. But the executor looks at the will and says, okay, they wanted this person to get this asset, or they wanted Zach to get the truck, and they wanted Kyle to get the car, and those kind of things. And so the executor is the person who the court gives the power and who you've nominated to do those things. So the executor just has the authority to distribute those assets. And for me, it's helpful to think about an estate as a bucket. So whenever someone dies, all of their assets are placed in this bucket. And the executor's job is to take those assets out of the bucket and do with them whatever the will says for them to do. Now, if there's not a will, then that person is considered to have died, and the fancy legal word for it is intestate. But if the person dies without a will, then there would be an administrator appointed. And there's all kinds of ways a person can qualify to be the administrator of an estate, but basically they do the same thing an executor does. The difference is they would distribute the property as per the intestate statute, or the laws of North Carolina say, okay, where there's not a will, here's how the property is to be divided. And so the administrator of an estate where there's no will would divide the property just like the statute says for them to do it. Now, guardians come into play in a couple of different places. So we talked about powers of attorney earlier. And if you have a power of attorney in North Carolina, you can nominate someone to be your guardian. Now that would come into play if you were ever declared incompetent. We see that unfortunately with Alzheimer's cases, with dementia, Parkinson's, those kind of things, where someone is unable to carry out their business affairs. They're unable to make decisions about where they're going to live and those type of things. And in those cases, you would have nominated a person in your power of attorney to be your guardian. Oftentimes, it's the same person you've nominated as your power of attorney, or you've named as your power of attorney. So that would be the person that would be the guardian of the estate and the guardian of the person. So when someone's declared incompetent, that person would be their guardian, basically make decisions on their behalf. A guardian in a deceased person's estate would oftentimes be the guardian of minor children, is what we think about. And this goes back to the age thing, where we talk about the age and younger people needing a will much more, or younger people needing an estate plan much more than elderly people. Because if a younger person who has children dies and neither one of the parents of the children are living, then you get in a situation where the court actually steps in and sets who the guardian of that child is going to be. And unfortunately, we know that there's all kinds of situations where families don't get along and in-laws don't get along, and you can have a place where there's a bunch of people coming in and they're all vying for the guardianship of these minor children, and they're just stuck in the middle. If we do an estate plan for younger folks who have minor children, they can nominate in their estate plan a guardian for those children. So you could say, hey, if something happens to me, I want Zach to take my kids. I want Zach and be their guardian. And the courts look at that and give it great weight. And usually, almost always, will approve the guardian that's nominated in that estate plan. So, and then the last thing is trustees. Trustees come into play where there is a trust, and trust can be used. They can be living trust, or they can be a testamentary trust. And testamentary trust is just a fancy way of saying a trust that comes into effect after someone has passed. Okay. Usually, living trusts convert to testamentary trusts after the person has died. And trusts are a really good way to avoid the probate process. So the probate process is where you have a will, and that will is taken to the courthouse, or maybe there's no will, and that estate is administered in the courthouse, and the clerks are involved, the courthouse is involved, attorneys are involved. There's quite a bit of expense and headache involved with that. We can do these things called trusts, where trusts are a separate entity. It's almost like creating a business where you have all of your assets placed in trust, and that trust is perpetual, basically, or it lasts until you tell it to dissolve. And people can put their assets in that trust, and when they're gone, the trustee manages their assets. So the trustee is the person who basically takes the place of the executor, steps in and manages those assets and does whatever the trust says for them to do, distribute it to Zach and Kyle or whoever the trust says to distribute them to. One thing about that for folks our age, for younger folks and younger than us, is they can say, okay, I want this trust to be managed for the benefit of my minor children. So a lot of this estate planning stuff is really, it's about your family and it's about your children and making sure your children are taken care of. If we don't have a trust in place for minor children, then the court kind of steps in and says, okay, we're going to be the guardian of the assets. And the court sets up what's called a conservatorship. Now, this should ring everybody's bells because of the whole Free Britney thing that we just had. If anybody follows any news at all, you've seen Britney Spears in the news fighting with her dad because when she was younger, the court set up what's called a conservatorship. And those things are really, I hate to use the word draconian, but they're very cumbersome. They're very difficult to deal with. For anything that you want to do for the children, you've got to go to a judge and get court approval and get that judge to sign off on it. Trusts are much more streamlined and much more user friendly. So we always encourage people to go the trust route, and that's where you have a trustee, and that's kind of where we started this rabbit trail we've gotten off on here, was talking about what is a trustee. And that is just the person who manages the trust assets in the way that the trust directs.
And while you were talking, a question came in over here from Michael. It says, Luke, what is the age requirement to be considered a minor? So 16, 18, 21, what is the courts in the estate process? Do you know is there a hard rule that they use?
Yeah, it's 18 years old. And that's an interesting and a good question, because one of the things that we do as part of the estate plan is we talk about, okay, your children, when they become 18, are considered adults. Do we consider them adults? And you can make that decision when you're doing your estate plan. So if you decide, and we often encourage folks whenever they're doing their estate plan, and in fact, my estate plan is this way. If something were to happen to my wife and I simultaneously, and our children were without their parents, we've nominated a guardian, so we know who would be taking care of our children. And we've set up a trust so that all of our property, anything we own when we die, would go into that trust. And then our trustee would manage that property, and we've directed that they would manage it until our children reach, and now I can't remember the age we said, but it's either 23 or 25 years old. And at the time they reach 23 or 25 years old, the trustees directed to distribute the assets in the trust. The reason we do that is we've directed the trustee to pay for their education. We've directed the trustee to cover anything that they need to live out of the proceeds or principal of the trust. But we don't want to dump several $1,000s or more on an 18-year-old person who's just graduated high school. We know what'll happen if that happens. If you don't have an estate plan, that conservatorship is going to be set up with the courts. And in North Carolina, I'm not sure what was up with the Britney Spears thing, but in North Carolina, when the child reaches 18 years old, that conservatorship ends. And so all of that property that's in the conservatorship is going to be turned over to the 18-year-old. And so there are some 18-year-olds who could handle that, but there are a lot of 18-year-olds who, they shouldn't have access to that. They really need to be encouraged to make a plan and kind of stick with it. 23, 24, 25-year-old, probably much more responsible.
Awesome. Thank you for that question, Michael. Can you give us, Luke, just a 30,000-foot view of if someone passes away, and you can choose to get into the weeds if you want, but what happens? What are the different outcomes if someone passes away and they have no will or no estate plan versus an estate plan, both with real estate and personal property? Our company deals with both, real property and personal property, and we've seen a little bit of everything with the way estates work. But 30,000-foot view, what are the outcomes with or without estate planning?
Sure, and we've kind of touched on that a little bit, but that's our our last point really in the 5 keys here is are just wills and trust, because everybody thinks about estate planning. They think, oh, I need a will. And yeah, that might be part of it. That might be what you need. But there's so many other things that we should be thinking about when we do your estate plan. We should be thinking about, all right, do you have minor children? If you do, we should really be talking about a trust, and maybe a will too, but we should definitely be talking about a trust. We need to be thinking about who the guardian is going to be. We need to think about, okay, how is this property going to be managed after I'm gone? And so everybody thinks about, okay, I need a will, but really that's just one small piece of it. And maybe you don't even need a will. Maybe there's other options that we can do that would better accomplish what you want to happen with your stuff. Because when someone passes away, yes, their property is distributed, but we need to be planning for that now. So if someone dies with a will, we can say in that will, here's exactly what I want to happen with everything. Here's how I want it to be distributed. But maybe we avoid the probate process altogether and just make that trust the probate, or the vehicle by which our assets are distributed. So there's all kinds of ways that can happen. If you don't have an estate plan, like I say, it gets really complicated. The court comes in and says, okay, there's a statute that says this is how your assets are going to be distributed. And one really complicated thing that happens is, if, like, my wife and I have 2 children, and they're 3 and 5 years old. If I didn't have an estate plan and I were to pass away, and if I owned real property in my name alone, then that property would go to my wife 50% and my children 50%. And if that's my house, if that's the house that my wife lives in, now anytime she wants to refinance, anytime she wants to sell and move somewhere else, anytime she wants to do anything with the property, she has to go before a judge and get the judge to sign off on that. And you have to have attorneys involved, and it gets really expensive. We can avoid all of that with a proper estate plan. So I always encourage people, let's sit down, think about your estate plan, especially if I'm doing closings where someone's coming in and buying their first house. If they're starting a family, we really need to think about your estate plan. And that's probably one of the most important things you can do. Nobody wants to think about it. Nobody wants to think, I'm 37 years old. I'm going to live a long time. I don't have to worry about it. But unfortunately, we know that's not always the case.
Yeah. And we've seen, that time and time again, both in our business, and I'm sure all the time. One thing I did want to mention to folks is, we've been a part of a lot of asset management while folks are still living, whether it be business liquidations or just estate planning on, hey, when I pass. We had a gentleman that we spoke with that when he passes, it's in his will that his tractor collection, it basically is going to be sold at auction, and then the proceeds from that sale he has directed to different philanthropic endeavors, and also to I believe it was children's school funds and whatnot. But that happens all the time, to where we are brought in, people think an auction, well, that's kind of the end game. That's we always come last to liquidate, assets from an estate. But the auction process, in the real estate sale process, whether it be traditional or the auction method, can also be part of a successful, an estate plan from the beginning. I want to, if anyone has any other questions, I don't see any in chat right now, but if you do, feel free to drop them in the chat there, or hit the little raise your hand icon. I'll be able to see that, or Kyle. I did drop all the contact information for Luke and myself into the chat window on YouTube when we conduct the video or produce the video. I'll put all that in the description because you can't see the chat window. But if if anyone has anything else, feel free to ask. Luke, I want to thank you for getting on tonight. Is there anything that we didn't cover? I know we had some loose notes we had talked about, but is there anything you want to add? If not, I don't want to drag this on. I appreciate people giving us 30 minutes of their time already. That's wonderful. But if you don't have anything, I'll close on out.
Yeah, the only thing I would add would be make sure you talk to an attorney. It doesn't matter if it's our office or some other office. We see all the time wills, things like that printed off the internet that folks use. And sometimes those things can work out, but most of the time, the vast majority of the time, they're done incorrectly and the court ends up rejecting them. And we end up having trouble and going back, and it's just not a good thing. So regardless of where you are, what your situation is, always contact your attorney. And like I say, that can be us, or there's multiple attorneys who do great work in estate planning. So just make sure and get in touch with one of those folks.
Awesome. Awesome. Well, Luke, thanks again. Luke Martin, folks, attorney with Benbow, Davidson, and Martin out of Statesville and Taylorsville, North Carolina. And again, myself, auctioneer and real estate broker, Zach Johnson with the Swicegood Group. Thanks for joining us tonight. If either of us can ever help in any way, shape, or form, feel free to call, text, email, smoke signal, whatever you have to do. We'd be happy to communicate with you and do our best to just provide some insight and some help. Luke, have a great night. And
You too,
y'all,
Zach.
thank you, sir. And y'all have a good night as well. Thanks for joining.
Thanks, everybody.